Okay, good afternoon, everyone. I hope that all of our participants can hear me. For those of you that don't know me, I'm Sally Gore, a barrister here at Fenners. I would like to welcome everybody, first of all. It's been a while since we did one of these on financial remedies, so it's really good that we've had so much interest. I also need to introduce our three speakers this afternoon. We're going to hear, first of all, from Geoffrey Deegan, a member of Fenners. He's going to speak about legal services payments orders. Richard Balchin is then going to follow up speaking about updates in financial remedies. And then we're going to have some concluding thoughts from His Honour Judge Spinks. So nobody's telling me or indicating that they can't hear. So I'm just going to hand over, I think, to Jeff. Over to you, Jeff.
Okay. I'm going to cover legal services payments orders. But to begin with, I'm going to spin you a yarn. I want you to imagine that you're in your office. Client knocks on the door, comes through, tells you that she's getting divorced from her husband, Donald. He's the president of the local golf club. She's had quite enough of him. He's become obsessed with excursions to Dubai and the Middle East, and he wants to take over his neighbour's garden. And she wants you to instruct, or she wants to instruct you to pursue a financial remedy claim. However, she's got no money and she can't afford to pay your fees, but by contrast, Donald is not short of a few quid. And so you tell her that it's been law now for some time, that under the Legal Aid Sentencing and Punishment of Offenders Act from 2012, the court has power to order him to, in effect, make a payment towards her costs. You will be well aware, I'm sure, because I'm sure many of you have contemplated these applications, even if you haven't made them, that under Section 22ZB of the Matrimonial Causes Act, there is a checklist of factors which the court must take into account if it's faced with an application. And that checklist of factors is not dissimilar to the checklist of factors under Section 25. The court will be looking at the party's income, earning capacity, property and other financial resources. It will be looking at financial needs. It will be looking at the matters in issue between them. It will take a view about any steps taken by either of them to avoid all or part of the proceedings, whether by proposing or considering mediation. That's probably become far more relevant, actually, in the last year or so than it was in the past. A failure, as you know, to attend mediation could not only be sanctioned by an adverse costs order, but a court could actually adjourn proceedings. So it's really important that you satisfy the mediation requirements. The court will also look at conduct and the effect of the order on the paying party. Under Section 22(3), you'll tell her that if you want to make an application for a legal services payment order, then that has to be a separate order from an application for maintenance pending suit. The two can't be tied in together. You can make two applications in the one D11, but what you can't do is you can't make an application for MPS and within that then seek provision towards legal costs. So you'll then go on and you will tell about the case of Rubin and Rubin, which is a case in which Mr. Justice Mostyn set out guidance as to the approach the court should take. And in that case, he said that the court will have regard to all the matters set out in Section 22B, that if the evidence in the form of an affidavit or forme filed by the payer, the respondent to the application, is deficient, the court shouldn't hesitate to make robust assumptions about his ability to pay, and in such a situation should err in favour of the payee. So if there's deficiency in disclosure, if it appears that he's not being straight, the court should make a robust assumptions about his ability to meet any order that's made against him. If it's the case that the respondent has been supported historically through the bounty of an outsider, but he says, well, that bounty has been curtailed. In other words, mum and dad, they've paid my legal costs today, but they haven't got any more money and they won't be able to afford to assist me going forward. But he doesn't produce any evidence of that, then the court's justified in assuming that that bounty will continue. One of the other factors is if the claim for substantive relief appears doubtful, then the court should judge the application for help with costs with caution. The court must also be satisfied that without payment, the applicant would not be reasonably able to obtain appropriate legal services. A LASPO should only be awarded to cover historic unpaid costs, where the court is satisfied that without payment, the applicant won't reasonably be able to obtain legal services in the future without those costs being discharged. The court shouldn't expect someone, the applicant, to sell or charge her home or to deplete modest savings. The court will require evidence of refusal by two commercial lenders that a litigation loan is not available, and it will also require evidence from the parties' solicitors that a Sears tooth arrangement can't be entered into. That having been said, that if a litigation loan is available, but it's offered at a very high rate of interest, then the court is unlikely to expect the applicant to take it unless the respondent offers an undertaking to meet that interest. The order should normally also contain an undertaking by the applicant that she will repay to the respondent such part of the amount ordered, if and to the extent the court is of the opinion that she should do so at the conclusion of the proceedings. One of the important points, of course, is that generally speaking, the court should not fund the applicant beyond the FDR, and it should then set a further hearing after the FDR, can't be before the same judge, at which the court will consider whether further funding should be made available. And one of the final points is that any order for funding should be by way of monthly payments. So, how do you make the application? If you're making an application for MPS, then you need two separate applications, both in the same D11. 14 days notice must be given to the other side unless the court orders a shorter time. There must be a written statement in support, and that must detail the costs incurred to date and those costs that are going to be incurred. Those of you who are familiar with civil proceedings will be aware that in multi-track cases, the courts are required to undergo what's called cost budgeting, and they have to file what's called a precedent H for the cost budget hearing, which in effect sets out for each phase of anticipated work, such as witness statements, disclosure, trial, instructing experts. It sets out the amount of time the fee earner anticipates spending on doing the witness statements or going through the disclosure process, and also what disbursements will be incurred, e.g. counsel's fees, experts' fees, those sorts of things. And it would be my advice that if you're making the application, then you need really to break down as best you can by reference to each piece of work that is likely to be done, what your costs are going to be. The statement should address all attempts that have been made to secure loans from family members, friends, banks, litigation loan providers, pawnbrokers, and attach evidence, obviously, supporting the fact that those applications have been refused. If there is any property, I would suggest that you set out your case in relation to being able to remortgage or secure a second mortgage, and if that's not possible, then why? Costs. If you make the application and you're successful, then it's likely that you would get your costs. Conversely, if you're not successful, then it's likely you could face an order for costs. And the reason for that is that the no order principle applies under Rule 28.4. The court can make an inter partes costs order. In deciding whether to make a costs order, the clean sheet rule applies. But under the clean sheet principle, the starting point is that the loser pays the winner's costs. One important point to note is that the court can take into account call to bank offers. So please make your call to banks if you make the application. Conversely, if you're faced with one, make a call to bank. Some other case law. She's got some savings, but she wants to know whether the court will take those into account. That is in part, we've already addressed that, but there's another case in which it was considered, the case of FRB and DCA from 2020. This was a big money case. The husband had various businesses. There was a final hearing in 2020 when he was ordered to transfer the home to the wife and pay her a lump sum of 49 million. Together with spousal maintenance of £60,000 per week. I had to read the facts of the case twice just to make sure I hadn't got the numbers wrong. Husband had been found to be dishonest during the final hearing. After the final hearing, the husband then applies to vary the amount of the lump sum and the timing. He failed in that application, but the wife also applied for a legal services payment order. And the reason she did that was firstly to fund the outstanding costs from the financial remedy proceedings which hadn't been paid by the husband, which were approximately £250,000. There were some upcoming proceedings which hadn't been dealt with in the main ancillary relief to argue about ownership of artwork, for which our anticipated costs were £368,000. And there were some Children Act proceedings in which the court was looking about whether the husband could take the children abroad, and her anticipated costs for that were £190,000. Husband's case was that wife should use her savings or charge her property. The court rejected that. She only had, I think, about £500,000 in the bank, and the court didn't feel that it was appropriate for her to have to invade those rather modest savings to fund her legal fees. I'm not sure that that's an argument which would really fly in the Cambridge or Peterborough County Court, but if you should find yourself down in the High Court doing a big money case, then you'll no doubt be relying on this one. The next case to look at is the case of JK and LM. And this is a case where the court had to consider whether it should award all of the costs that were being claimed, or whether it should apply a discount to reflect the fact that if the parties went at the end of the case on assessment, having secured a favourable costs order, there would inevitably be on assessment a degree of reduction to the costs claimed. So what happened here was it wasn't actually a financial remedy case. The parties weren't married. It was an application under Schedule 1 of the Children Act, but you can make applications for legal services payment orders in those cases as well, and the same principles apply. The parties had been in a relationship. They separated in 2019. There was one child, the father lived abroad, and in 2022, he had been paying maintenance. He reduced the payments. Mum bought an application under the Children Act for financial provision. Mother's case was father was very wealthy. She was on universal credit with limited means and unable to afford representation. The court awarded her a sum of money to pay her costs, but reduced the amount sought by 15% to reflect what might be awarded on an assessment if she secured a costs order against the father. Of course, that inevitably leads to solicitors being tempted to inflate their original estimate of what they're likely to incur in undertaking a case, being conscious that inevitably they're going to be knocked back when it comes to making the application. So you get your legal services payment order against Donald, but he doesn't pay. What then? How can you enforce? Well, there are a couple of cases to look at. The first is LK and TQA. Just running through that quickly, it was a foreign divorce application by wife under the 84 Act. She applied for interim PPs, which included a provision for costs, that being the one exception to where you don't have to make a separate application. At the hearing, her costs or outstanding costs were 200,000, which she couldn't afford to pay, and her future costs estimated at 250. The court awarded her interim periodical payments plus £250,000 towards future costs in monthly instalments. Husband doesn't then pay. However, he does pay his solicitors £95,000 in costs. The wife's solicitors continue to act. They go back to court. The judge was very angry with the husband, and he made what was called the pound for pound order, which is in effect an injunction, because it said to the husband, you can't pay your solicitors anything unless when you do, you pay an equal sum to the wives. And of course, the solicitors would be bound by that. Another way of enforcing an unpaid order is to make an application to commit, which was done in the case of John de Death from 2022. Or another avenue might be to pursue what's called a Hankinson order, and this comes from a case called Defagori in 2018. And in that case, what had happened was that the husband was ordered to pay the wife's interim maintenance and costs. The court then subsequently increased the interim maintenance, and they make a legal services cost order for the outstanding costs and future costs. Husband doesn't pay. The wife then applies for a Hankinson order, which was an order prohibiting the husband from pursuing an appeal in the divorce proceedings, so in a side case, unless he paid what was owed. And Lord Justice Peter Jackson effectively set out that there are 4 conditions to be satisfied if a Hankinson order is to be made. The first, and the reason for that is because a Hankinson order is draconian, because it's affecting a litigant's right of access to a court, and he felt it shouldn't be commonplace and an order of last resort. But what he said was, firstly, you have to establish that the respondent is in contempt of an order of the court. Well, clearly this chap was. The contempt was deliberate and continuing. He felt both of those conditions were satisfied, that there would be an impediment to the course of justice. That was the third condition. Well, of course, here the wife's access to justice was impeded because the husband wasn't paying her costs and she couldn't afford to pay it. He felt that condition number 4 was that there was no realistic and effective alternative remedy. And finally, that the order is both proportionate and goes no further than is necessary. So that's the case law. Just one final thought, and I'll cover this very quickly because I know others are eager to spill their wisdom. The elephant in the room, why are there so few applications? My only thought about that and you'll have a much better idea, because I suspect it's something you do think about when you have clients who are struggling to meet your costs, is that it's the cost of making the application when there's no certainty or guarantee that it's going to be successful, and the risk that if you make the application and you fail, your client could be on the end of a costs order. I know from my own experience that in the last 13, 14 years, I've done a handful of these, maybe 3 or 4, and from the people I've spoken to, their experience is not dissimilar. There aren't many counsel, I don't think, who will say this is something I'm doing on a regular basis. As Donald Trump would say, thank you for your attention. Sally?
Thanks, Jeff. Over to you, Richard.
Right. Good afternoon, everyone. In the good old days, we looked at the bound volumes in our library of family law reports and All England's and Family Court Week and the like. These days, how do you keep up to date? Well, our clients keep up to date, as they always tell us, on Google AI and come up with their law reports from there. We've, of course, got Twitter, and you can get an enormous amount of information from the relevant publications there. The Financial Remedies Journal is an absolutely indispensable read on a regular basis for keeping up to date. And LinkedIn, which is where I'm going to start, because I'm a follower, or is it a disciple, I can't remember, of the former Mr. Justice Mostyn. And I want to start briefly by taking you through his latest thoughts, published, I think, yesterday, in terms of transparency. The title, Thoughts on the Coppinger-Symes Appeal Judgment, and he doesn't hold back. He says, I've pointed out the weird inconsistency between first instance financial remedy judgments, which are almost invariably anonymised, and those in the Court of Appeal in the High Court when it sits on appeal, where they are not. The defenders of the cult of secrecy, he goes on to say, justify this disparity by using 2 arguments. First, they point to the fact that a factual detail under consideration is likely to be more wide-ranging in the court of first instance than on appeal, and that militates in favour of giving litigants privacy. He then goes on to say, in the second appeal, shows just how hopeless this argument is, not a dry legal argument based on facts found at first instance. Lord Justice Negee sets out in pitiless detail the written and oral evidence of the in-laws, including painfully private material reflecting their religious belief. Yet nobody ever thought of suggesting that the appeal judgments should be anonymised. It is completely illogical to suggest that appeal judgments that descend into detail should be anonymised, whereas those that do not should not. He goes on to describe the final report of the Transparency Implementation Group as being also completely illogical. Why does this public systemic function of the Court of Appeal, he asks, mean that the first instance anonymisation should be lost on appeal? Well, he goes on to say, the system relating to transparency in the first instance financial remedy litigation is illogical, incomprehensible, inconsistent, irrational, and not fit for purpose. I've pointed out previously that in certain respects it is clearly unlawful. It is a complete disgrace that it is allowed to limp along in its present form. The Court of Appeal urgently needs to get hold of a case and issue definitive rulings, for better or for worse. The present uncertainty and intellectual chaos surely cannot be allowed to continue. There will be more to see in the subject of transparency in the courts later this year, or indeed here on Mr. Justice Mostyn's Law and Disorder podcast. So back to black letter stuff. The most important document you need to read this week and next week, perhaps this year, is the new glossy Financial Remedies Court Guide 2026 that was published only a few days ago. I'm not sure it's in hard copy yet, but it's certainly on the judiciary website, the public-facing side of that website. And I'm going to pick out, not everything, of course, but I'm going to pick out the key points that I suppose matter most to me. Talata claims can, of course, be dealt with in the FRC, and paragraph 11 carefully links back to the Financial Remedies Journal article on the jurisdiction of the family court to determine property disputes in favour of third parties. Reminder, you need to remind litigants in person on the other side of you that they need to send their documentation to HMCTS in Harlow. They do not have access to the portal. That may be something that changes in the near future, but at the moment, everything needs to be sent to Harlow. And of course, Harlow takes quite a long time to upload. So I would encourage them, if I may suggest, that they send it ahead of the deadline. Otherwise, it simply will not reach the portal. Paragraph 24 reminds FRC judges, in deciding what order of any to make that requires a party to pay the costs of another party, judge must have regard to any failure by a party without good reason to attend a MIAM or attend non-court dispute resolution. Paragraph 26, where a private FDR appointment has taken place, the parties shall provide an explanation to the next FRC judge dealing with the case, unless the case settles, of course, so that they can be assured that a thorough FDR exercise has taken place. But it should not include any reference to without prejudice positions, but simply be limited to basic factual details: whether it took place, when it took place, whether both parties attended, the identity of the FDR evaluator, legal teams, location, length of private FDR appointment. Paragraph 58 helpfully reminds everyone that litigants in person are also expected to provide an ES1 and an ES2. Now, neatly included in the guide are various back references to documents we have all probably forgotten about. And in paragraph 80, there is basically a cut and paste from the President's memorandum witness statements from the 10th of November 2021. Do you remember that? Because it makes very clear that witness statements may only contain what is called evidence, not quoting from any document, not seeking to argue the case, not to set out contentions that are best left for argument, not to express opinions of the witness or use rhetoric. How many times have we all seen witness statements that do all those things rather than actually focus on the facts? Those statements must indicate the source of any matters of information. Key documents may be exhibited to the statement, but their number must be limited so that the 350-page bundle limit is not exceeded. And again, you may want to have a discussion with the litigant in person on the other side that they do not need to attach 600 pages of exhibits to their statement. Statements should not, as per the President's memorandum, exceed 15 pages in length. Bundles. We've probably all been trying to struggle with the bundle and numbering and the difference between FRC bundles and children case bundles. The key point: internal and PDF numbering must match. Correspondence, including with experts, bank or credit card statements, other financial records must not be included unless a specific prior direction of the court has been obtained. Interestingly, in this update, a separate bundle of all authorities relied on must be prepared and agreed between the advocates. There is a convenient link, which I would suggest you all have on your computers, to the judiciary's new guide that they brought out just behind the new practice direction, Preparing Court Bundles for Family Proceedings Guide for Litigants in Person.pdf, which frankly is a good easy read and you can understand it more easily than in any other way. Position statements have also been carefully defined. So first appointments, the old era of 20-page position statements at first appointment is now limited to 6, 8 at other interim hearings, 12 as being the maximum, not the expected, at FDR appointments, and so on and so forth. Fonts. Anyone who gets to a certain age and has to stare down at a small screen will appreciate this. Fonts have to be 12-point, 1.5 line spacing, and in Times New Roman or Arial to help those who are neurodivergent. Of course, Arial is 10% bigger than Times New Roman, which is 10% bigger than the fashionable Garamond font. So you've got to choose your font accordingly. Position statements should define and confine matters in dispute to be resolved at that particular hearing, be cross-referenced to any relevant documents in the bundle, self-contained, not incorporate reference from previous position statements, not contain extensive quotations, and this is the interesting one, not introduce any new factual allegations or evidence. Well, how many times have we seen that being breached? No exhibits, set out directions or orders sought. A reminder in the new guide that drafting of orders must fully comply with the 2021 President's Memorandum on Drafting Orders, in other words, on the same day or within 48 hours. And orders should not seek to summarise what happened at a hearing, but should record shortly and neutrally what exactly was ordered. Parties must not, it says, seek to attribute views to the court in recitals which did not form part of the court's disposition, and should not recite the parties' respective positions before or during the course of the hearing. There is also at the back of the guide a careful list of reference material. It's probably best advised to send to litigants in person on the other side, including an animated guide called Courtney.legal, which is actually quite good. More substantive law then. Non-matrimonial assets. Well, Standish hasn't died. Sir Jonathan Cohen in RRE and JPR EWFC 7 has weighed up Mr. Justice Peel's judgment in NV and JD from 2022 with Standish, done a thorough analysis of that, and perhaps added a new judicial gloss, reminding us all that transfers of capital assets with the intention of saving tax do not, without some further compelling evidence, establish that the parties are treating the capital asset as shared between them, something that I think probably most of us have tried to overlook at various times during our careers with our clients telling us what they have done and for what reason. Back to transparency. Arbitration confidentiality in particular, and the case of the Earl Spencer and Countess Spencer from 2025, EWFC 431, decided by Mr. Justice Peel. Setting out the following: a well-established principle that arbitration proceedings are generally private and confidential, in that there is an obligation implied by law and arising out of the nature of arbitration of both parties not to disclose or use for any other purpose any documents prepared for, disclosed or produced in an arbitration. That's repeated essentially in the Family Law Arbitration Scheme arbitration rules. But Mr. Justice Peel goes on to say, the general principle is not absolute and is subject to exceptions. Those exceptions include, and there's a reference to paragraph 103 of Emmett and Michael Wilson and Partners from 2008, with the express or implied consent of the parties, where the court has given permission, where reasonably necessary for the protection of an arbitrating party's legitimate interests, as yet further defined, where the interests of justice or public interest require disclosure. The judgment goes on to say an expansion of the terms of disclosure beyond that which was specifically authorised by the arbitrator risks undermining the fundamental assumptions of privacy and confidentiality attaching to the arbitration. As counsel for the husband submit to permit expansion as sought by the wife, the Countess, would drive a coach and horses through the confidentiality central to the arbitration process. So perhaps a good reason why NCDR may involve arbitration. Another form, of course, is private FDRs, and Mr. Justice Peel has dealt with the importance of private FDRs in BC and BC 2025 EWFC 236, when he reminds everyone, pursuant to FPR Rule 9.17, an FDR appointment is to be treated as a meeting for the purpose of discussion and negotiation. Parties must approach the occasion openly without reserve, Non-disclosure of the content of such meetings is vital and is an essential prerequisite for fruitful discussions. Evidence of anything said or of any admission made in the course of an FDR appointment will not be admissible in evidence, except at the trial of a person for an offence committed at the appointment or in certain very limited exceptional circumstances. Mr. Justice Peel goes on to talk about the FDR being an integral part of the court process. Its value has been proved time and time again. It allows the court, the tribunal, the evaluator to look behind the litigation posturing, which is so familiar in these cases, and give clear, robust views. The President's Circular of Financial Remedies Court Pilot Phase 2 of 2018 is repeated, in which the President then said, "I hope that the lead and other judges take the opportunity to develop and encourage the use of private FDRs locally. Private FDR is a simple concept. The parties pay for a financial remedy specialist to act as a private FDR judge. The very fact of investment by the parties will signify a voluntary seat at the negotiating table. The hearing can take place at a time convenient to the parties," and goes on to say, even at the weekend or in the evening. Well, I've yet to do a private FDR the weekend, but I suppose I'm fair game if anyone else is. The confidentiality of the FDR process is jealously safeguarded. A reference back to V&W from 2020, when a husband wished to rely on a transcript of a court FDR to assist him in civil proceedings against a single joint expert accountant, and Sir James Munby then refused the application, saying, "The rules say what they say. There is an absolute bar to make use of anything said or done at an FDR." So, citations now. There has obviously been a massive expansion in the number of authorities, as it were, published on Bailey and in numerous other journals. The President has taken issue with this and tried to clamp down on everyone trying to use district judges' decisions as binding authority and the like. His citation of authorities' practice note from the 24th of February 2025 makes clear circuit and district judge level judgments should not be cited unless they contain an express statement the judge intended that the judgment should be citable. Judgments that do not contain such an express statement will not be citable. It is not expected that the practice of including a statement as described above will become common. It will not apply to judgments where the judge has applied existing law and provided examples of how the law operates. It should be reserved for probably very rare cases where new ground is being broken, and the particular judge who, DJ or CJ, who publishes such documents should always only do so with the approval of the appropriate leadership judge in terms of that particular certificate. Cost of sale. How many times do we have this argument? Is it 2%? Is it 3%? Is it 2.5%? A reminder to everyone. Benghazi from 2009, Lord Justice Wilson, as then was, said in the absence of evidence to the contrary, they should be taken at the percentage nowadays conventionally taken in respect of the sale of real property in England and Wales, namely 3%. Well, over the last few years, there has been a ream of cases at lower level, some of which reported, none of which are binding authority, discussing whether 3% is actually realistic these days. What is the actual level of costs of sale that people are actually having to pay? Well, to break the golden rule, L&L 2021, just a reminder, His Honour Judge Booth, sitting as a Deputy High Court Judge, resolved the issue and decided 1.25% was appropriate, relying on judicial notice of the housing market in the absence of expert help. And he suggested that the single joint expert in the case could have been asked that question. So why? Why do we go for 3% when we've got a dead market? Estate agents are desperate to sell anything these days and are giving sellers very good deals. It might be academic, but it may be important. Again, probably breaking the rule because I haven't checked whether this particular judgment has the necessary certificate at the bottom, but because His Honour Judge Hess is, I suppose, number 2 in the Financial Remedies Court, he has produced a judgment dealing with post-separation income and equest, pretty recently, OS and DT, where he weighs up what Mr. Justice Mostyn said in EVL from 2021 and what Mr. Justice Roberts said in CC from 2018. What are the dates we need to use when deciding these issues? In Mr. Justice Mostyn's case, he went back to Cowan and Cowan, when Lord Justice Thorpe said the assessment of assets must be at the date of trial or appeal. The language of the statute requires that. Exceptions to that rule are rare, probably confined to cases where one party has deliberately or recklessly wasted assets in anticipation of trial. It's a reference to a comment of Lord Justice Mance saying that to take the date of the trial and the end date was traditional. But then there's a discussion about all the potential permutations on a theme with respect to post-separation bonuses, for instance, which Mr. Justice Mostyn, in that particular case, classes non-matrimonial unless it related to a period which commenced at least 12 months after the separation. In C&C, there was a potential challenge to that in terms of what are the dates that we should take into account with respect to post-separation future resources and the like. Well, the reason why all that's important is His Honour Judge Hess said this: on closer analysis, these approaches that were considered to be rival approaches are not necessarily inconsistent with each other. The origins of the 12-month runoff and bonuses approach advocated by Mr. Justice Mostyn can be seen in scenarios where there are complications involved with identifying whether an amount of money received on a particular date was a result of endeavour prior to the separation or after it, or perhaps a mix of the two. Bonuses received after the separation can sometimes be wholly or partly the product of endeavour prior to the separation. And this is, I suppose, is the key point at circuit and district judge level. In such cases, the court has to make a, quote, broad assessment on the facts of the case. He goes on to say, applying these principles to the facts of this particular case and exercising a broad discretion to achieve a fair outcome, I have decided that it would be, in that particular case, unfair to exclude, etc., etc., etc. We don't need to get too particularly in depth about those particular issues, I would suggest, in the vast majority of the cases we deal with. Now, His Honour Judge Hess, in the same case, also provides, this is the OS and DT case in 2025, also provides a very helpful, in my view, guide to the interface between child support and child maintenance. He reminds us all that, save for the intervention of the Child Support Act in 1991, the court would have the power to make a child periodical payments order in favour of one parent against the other, even if parents share the care of the child exactly equally. He reminds us that under Section 8.1 and Section 8.3 of the Child Support Act, the court has prevented, save in specified circumstances, to make a child periodical payments order when the CMS would have jurisdiction. He reminds us, and this is sometimes, I'm afraid, overlooked, the CMS has no jurisdiction when one of the parents of the child are habitually resident outside the United Kingdom. And of course, there is the top-up jurisdiction where the payer's income exceeds £3,000 per week gross. There is a reminder of the Dixon and Rennie case from 2014 for a party to obtain a CMS maximum income assessment before pursuing that application, though that is not necessarily mandatory. He says, it follows from the above that my view is that in a situation where there is an established agreement or order which clearly provides for parents to have exactly equal care for a child, either party can apply to the court for a child periodical payments order, and that party does not have first to make an application to the CMS. He makes further reference again, Janes and Seymour in 2023, expressly includes calculations for court orders where there is equal shared care, which adds force to his conclusions. I'm probably going to end now with the question of conduct. We're all familiar with the orthodoxy about conduct cases and the potential for that orthodoxy to evolve. Well, this year, Mr. Justice Cusworth has dealt with two of these conduct cases. I suppose the leading one, if there is a leading one this year, is LP and MP from 2025. He reminds us all of what Mr. Justice Mostyn said in OG and AG. There are various different types of conduct. But he goes on to talk about gross and obvious personal misconduct meted out by one party against the other. In that particular case, the wife pleaded guilty to 2 criminal counts of financial fraud, but he wasn't satisfied that the fraud of itself was sufficient to justify any recalibration of the wife's award. But he does usefully remind us back of what Mr. Justice Peel said in the K. Rover case from 2023, what a party asserting conduct must prove. The facts, if established, that those facts meet the threshold of exceptionality or high level, an identifiable, even if not necessarily always easily measurable, negative financial impact, and a causative link. All of those need to be set out as soon as possible during the course of the proceedings. There is a reference back to Goddard Watts from 2023, Lady Justice McCure, analysing the position that there must be necessarily quantifiable monetary terms rather than be seen as a penalty to be imposed against the errant partner, and that the orthodox approach to litigation misconduct is to be met with an award of costs. Query. Where there is a direct and slightly direct, indirect, or slightly direct financial consequence to the behaviour. It is not for a financial remedies court. Mr. Justice Cusworth says to impose a fine, a penalty, or damages upon a party for conduct. But whilst the statutory test that conduct must be such that it is in equitable disregard really means no more in ordinary language, and the behaviour should be taken into account if it would be unfair to ignore it. Mr. Justice Peel is right that the higher courts have set the threshold for applying section 25(2)(g) at a very high level. Nonetheless, Mr. Justice Cusworth says, I consider that there is a real risk of unfairness to the victims of violent or coercive controlling behaviour if the lack of readily quantifiable financial loss prevents the courts from even considering the fairness of taking the assailant's behaviour into account in determining the outcome of a financial remedy application. Such behaviour may well have hard to predict but potentially far-reaching consequences, in some cases for the victim's prospect of achieving self-sufficiency, in others for a fair financial outcome in all the circumstances. That does not mean that the fact of such behaviour will inevitably lead to a different award, but in the right case, it should do. Well, that's conduct. I said that would be the last case. It's not. We always end these proceedings with chattels. And there is a clear steer by Recorder Rees Taylor, King's Counsel, KFK and DQD 2024. The overriding objective includes the requirement to allot an appropriate share of the court's resources to the dispute, whilst taking into account the need to allot resources to other cases. This case, or that case, has now had a fair share of judicial time. He gave the parties 28 days to resolve their differences regarding chattels, restored the application from himself within 35 days if they hadn't. However, he continued, I make plain, if returned to me, I reserve the option of requiring all disputed items to be sold on eBay or the like, with the parties each being free to bid for items or to enjoy a 50-50 division or whatever net sum is produced from the sale. That's nice and convenient, isn't it? I've had too much of your particular time, so I will pass now on to His Honour Judge Spinks.
Thank you, Richard. Can you hear me?
Yes.
Yeah, very good. Thank you. I'm just going to make a couple of points. One is a very boring administrative update, but then otherwise just to touch upon a couple of points of practice that really arise from recent conversations and questions that I've been asked about the local practice of financial remedy. I'm going to start, however, by both thanking Richard and Jeff for their talks, and also to apologise for having nipped out for about 10 or 15 minutes during Jeff's presentation. I had an FDR out, which I'm happy to say settled following a determination about the right level of costs of sale. So very topical was that. On financial remedy generally, I'm just looking at the screen. There are 118 attendees in this meeting, which I think is excellent. I appreciate it's online, but that's a really good number, and it demonstrates by itself the importance of this area of work. I know that this seminar, I think, has been advertised on LinkedIn and elsewhere, so not necessarily all of you are very local, but a very good number of you will be. And that is in stark contrast, it seems to me, to the allocation of resources within family more generally. The president of the family division, when allocating sitting days within family, allows only 9% for financial remedies, despite the obvious importance for separating couples in sorting out property, money, and the rest of it. I also think that it's really helpful to have these seminars, perhaps more frequent than they have been in recent times in financial remedy, and for us to receive both the general update that Richard's given, and for us to be reminded about discrete areas that don't come up that often, certainly in my experience, such as the LASPOs. I don't have any particular perspectives on LASPOs or otherwise. As I say, they come up fairly infrequently, and so it's really important and helpful to have a reminder of the relevant law and rules and procedure when they do. Both in different contexts, Jeff and Richard touched on mediation, non-court dispute resolution more widely and generally, and of course I would add a reminder of the extended court powers now to adjourn or stay proceedings where the view is taken that insufficient attempts have been made at out-of-court settlement. On a sort of related point, one of the practical questions that I've been asked recently is the proper approach to listing FR cases where there is a private FDR. And my understanding, not just of best practice, but actually what is required is, firstly, where at the first appointment you are setting one up. This is not based on a sort of general sense of willingness from the parties. There needs to be in that order details of who the tribunal is, the date of the tribunal, and so on, so that the idea is this really happens and is made to work. Insofar as the court proceedings, they should be listed for a directions hearing at the other side of the private FDR, not another court-based FDR, as it were, operating as a backup, because that is a disproportionate use of court time. The administrative point that I said that I would update you all on relates to HMCTS reorganising the way that FR work is administered across the southeast, and you will all be aware that our hub, it's called, consists of the 6 counties. The hub, or the main court, is going to be Peterborough, and the idea is that all of the staff will be centralised there. Quite what the impact on practice is going to be, I don't yet know. I have sought and received assurances that staff will be recruited in order to make that work. I'm told that HMCTS will be successful in increasing the staff numbers in Peterborough from the current 3 to just over 9, allowing for some part-time working hours. I remain to be convinced, but over the coming months, each of the counties, I think starting with Hertfordshire, so that's Watford and Hertford, will come, as it were, into Peterborough and be administered from there. I don't know or think there is as it were, an LFJB general email or whatever, but if those of you that would like to be kept up to date with that could send me, for example, a firm email or a, as it were, a collective email. I don't really want 125 separate emails saying please update me, but I can pass the email addresses on to the operations manager in HMCTS that's responsible for overseeing all of that. The other practical points, and I just recently had an email from my friend and colleague Judge Sprague, so I'll deal with that now, asking me to remind practitioners that when, in the very, very rare event you don't manage to resolve matters at an FDR, the order includes a listing for the final hearing not in front of the FDR judge. I'm not sure that I've seen many that don't, but he tells me not many of them do at present. So that should go in for very obvious reasons. When agreement is reached to progress the case such that, for example, attendance at a first appointment is not required, please bear in mind, and Richard's not just touched on it, he's taken us through a number of the paragraphs within it, the publication this week of the 2026 Financial Remedies Guide. Within that is incorporated the Statement of Efficient Conduct and the primary principles, which make clear the importance of court oversight on things like questionnaires. The number of orders, draft orders that I see that say, we've exchanged Forms E a bit late, we'll do questionnaires in 2 weeks, and then we'll answer them 4 weeks after that, subject to just exception, are non-compliant with the rules, and I do not approve orders like that. The questionnaires need to have been exchanged and sent to the court in order for that order to be made in those terms. Otherwise, what will happen, or what should happen, is that you will be listed instead for an adjourned first appointment. Please do not include in draft orders provision for schedules of deficiencies. They don't need to be in orders. If a party really takes the view that replies are deficient, that doesn't stop you filing a schedule of deficiency. But I really don't think the focus should be on the expected provision of them within the court orders. Otherwise, I think that a panel discussion, I've got 2 minutes past 5 and was told that this was about an hour-long seminar. So I hope those brief thoughts are okay, don't surprise or indeed upset anyone. I've thanked Jeff and Richard, but also on behalf of all of us, I think, because it takes a lot of work and organisation in setting this up. And it's, I think, both Sally and maybe Lisa Hammond. Credit where it's due. Is it you, Sally, or is it you and Lisa? But thank you.
It was released from Penny, really.
Oh, it was Penny. I'm so sorry. So thank you to all three of you. And in addition to getting together like this reasonably frequently, I am, for obvious reasons, in full support of financial remedies being the main subject matter. So thank you. I'm happy to take any questions if there are any, or observations, but that's really what I wanted to say.
Right, well, thank you very much to all three speakers. I think that was three really interesting and helpful talks. I'm afraid Jeff's had to go because he was broadcasting to us from a conference room in Watford, and I think security have kicked him out. But we do usually do a very short sort of Q&A session at the end of these webinars. So if anybody does have a burning question for any of the panellists who are still here, then do feel free to sort of raise an electronic hand. I can see somebody's typed in the Q&A box. Oh, so thank you. So we have the Q&A box that you can probably see at the end of the at the bottom of the screen, or if anybody wants to raise a hand, I think I can unmute you. If you just unmute yourself, I think you'll be able to speak. Oh, see, somebody said, can the legal service order be dealt with at the FDA hearing, or will it be listed separately?
Two really good points. I know it sounds unkind. There's no such thing as an FDA. The portal thinks there is, and the portal thinks it stands for First Directions Appointment. That is not a hearing recognised by the rules. It's a bugbear of mine, but it's really, really important because going along to a hearing which is treated as just a directions hearing gets the tone all wrong. There is actually provision, as you'll all know, in the rules for that first appointment to be converted to an FDR wherever possible. So please, can we all get into the habit of calling them first appointments? The answer, so far as my understanding is concerned, is yes, if it's been set up in the right way and the time estimate permits. I think it's a case of it's up to the individual judge, depending on what sort of issues and the amount of evidence that the LASPO application involves. But there's no procedural hurdle to it. The answer would be different, of course, if it were at the FDR, because the FDR judge can take no further part in the case, having conducted an FDR. But The answer is yes, in principle. There may be some circumstances where time estimates, amount of information mean that a separate hearing have to be listed, but I would try and avoid that wherever I could. Is that right, Richard, or is there a procedural hurdle that means I'm wrong?
No, well, it depends on timing, doesn't it? And the court list.
Yeah.
I suppose in a busy first appointments list, when the judge will have probably a couple of FDRs and a 3 or maybe 4 first appointments, there simply isn't going to be the time to deal with anything more substantive.
Yeah.
I can see there is a hand raised. Rebecca, if you can unmute yourself, if you do have a question to ask. Or alternatively, if you type in the box. And I've just seen that somebody has asked about Richard's notes. They will be made available on the Chambers website, hopefully later this week. I think Jeff's may have already been circulated. Right, well, I think unless there are any further questions, I will probably end the webinar there because we have run slightly over. But thank you very much, everybody, for coming. It is, as I say, really good to see so many people attending one of these. Okay. All right. Thank you very much. Have a good evening, everybody.
Thanks, Sally.
Thanks, Sally. See you soon.